Good afternoon. Welcome to Prep and Advancement Projects webinar on school discipline. My name is Andrew Hairston. I'm the George N. Lindsay Fellow and Associate Counsel in the Educational Opportunities Project of the Lawyers Committee for Civil Rights Under Law.
And my name is Jessica Alcantara, and I'm the Skadden Fellow Staff Attorney at Advancement Project, where I focus on legal issues related to school closures as well as the school to prison pipeline.
And I'm Natasha Quiroga. I work at the Lawyers Committee where I manage our prep program and am senior counsel in our Educational Opportunities Project.
And hi, everybody. My name is Caitlin Banner. I'm a senior staff attorney at Advancement Project, and I work with our Ending the Schoolhouse to Jailhouse Track program.
We are so thrilled that you have joined us for this webinar on school discipline. Before we get started, we want to provide some background on the Parental Readiness and Empowerment Program, or PREP, and what we do, as well as information on Advancement Project. PREP is an initiative of the Lawyers Committee that seeks to inform parents of the civil rights of their children in school, as well as teach effective advocacy skills. Please visit prepparents.org to learn more about our work and download state-specific guides on special education, discipline, and other topics.
And the Advancement Project is a multiracial civil rights organization that supports and inspires community-based solutions to racial injustice by utilizing strategies of the civil rights movement. By sharing legal analysis, data collection, policy development, and communications expertise with community organizing groups, Advancement Project helps to inspire and amplify the voice of community-based efforts and grassroots movements for change toward universal opportunity and just democracy.
Now, we must emphasize that this webinar is not meant to be legal advice. The information contained in this presentation should only be taken as general advice on how to deal with school discipline challenges that may arise during your child's education. If you have a legal issue that concerns your child, we encourage you to consult with a licensed attorney in your state. With this information in mind, we can get started.
First, we want to hear from you. Please take some time to indicate whether you are a parent, teacher, school administrator, community partner, or advocate. All right, let us.
Yeah, ask them to type in the chat box.
You can type in the chat box to indicate your responses.
Okay, so let's begin our discussion of school discipline. In a broad sense, school discipline refers to the rules and laws, federal, state, and local, that govern how teachers and other professionals should respond to your child's behaviors in school. Specifically, starting in the late 1980s, harsh school discipline policies known as zero tolerance emerged in many states. These rules are often worded vaguely enough to be broadly applied, such as the offense of disorderly conduct, which can encompass a range of actions from simply talking back to a teacher, to violating the school's dress code, to walking in the hallways during class time. The punishment for these actions can range from in-school suspension to, in extreme cases, expulsion. These policies are often disproportionately used against children of color and children with special needs.
Harsh school policies and practices and an increased role of law enforcement in schools have combined to create a schoolhouse to jailhouse track, in which out-of-school suspensions, expulsions, and school-based arrests are increasingly used to deal with student misbehavior, especially for minor incidents. And huge numbers of children and youth are pushed out of school and into the juvenile and criminal justice systems. This is more than an education crisis. It is a racial justice crisis because the students pushed out through harsh discipline are disproportionately students of color. Students with disabilities and LGBTQ students are also disproportionately impacted by these policies.
According to a report released by the Department of Education's Office of Civil Rights in June 2016, Black K-12 students are 3.8 times as likely to receive one or more out-of-school suspensions as white students. In another alarming statistic, K through 12 students with disabilities served by IDEA are more than twice as likely to receive one or more out-of-school suspensions as students without disabilities. We know that overuse of suspension, expulsion, and other harsh disciplinary policies increases the likelihood that youth will enter the juvenile or criminal justice system. Suspension is linked with lower ratings for overall school climate, lower academic performance among students, lower school-wide academic performance, and an increased likelihood of school dropout. Decades of social science research, quantitative data, and the lived experiences of devastated families and communities tells us these policies are putting youth, especially youth of color, on a pathway to prison. We encourage you to view our supplementary video on exclusionary discipline practices for more information.
Communities across the country have attempted to fight back against these harmful exclusionary discipline policies, and one of the alternatives to harsh discipline that has grown in popularity in recent years is restorative justice. Restorative justice is an evidence-based practice effectively used to reduce suspensions, expulsions, and disciplinary referrals. It focuses on righting a wrong committed and repairing harm done, with the goal being to place a value on relationships and focus on repairing relationships that have been harmed. A common example of restorative justice is a school administrator organizing a meeting where the teacher and student can discuss their sides of the story and have a meaningful conversation about what occurred and discuss how to make it right. Certain schools throughout the country employ other students to serve as mediators to help the dialogue flow more smoothly, and the consequences that are decided on, if any, usually involve making amends to the harmed parties in ways that don't remove the students from classroom setting. Restorative justice ultimately leads to greater understanding between teachers, students, and other professionals in school settings, helping to create safe learning environments through community building and redressing those issues, redressing damage. Most importantly, it serves as an alternative to zero tolerance policies that result in students, particularly those of color, being involved with the criminal justice system at a young age.
We want to hear your thoughts. Based on the information you've learned so far and based on your experiences, use the comment bar, the chat box, to let us know if you have seen examples of restorative justice or other alternatives to suspension and expulsion in your child's school and how it works. Now let's turn our discussion to school resource officers, which may be a familiar term for a number of our participants. School resource officers are police officers, often employed in local police departments, who are stationed in schools and often administer discipline to students. The use of SROs greatly expanded after the shooting of Columbine High School in 1999, which put school safety in the national spotlight. Policies aimed at preventing another mass school shooting, however, resulted in the expansion of SROs and their authority. Despite the fact that Columbine High School was a suburban school over 90% white, school resource officers are most often employed in schools where most of the students are students of color.
Recently, we have seen many videos and instances of school police inflicting harm on students, usually on Black or Latino students. These incidents have led some to question whether school police are actually making schools safer, or whether they are merely causing more harm and damage to our school children. In an attempt to address this problem and the increasing scrutiny of school police, the U.S. Departments of Education and Justice recently released federal guidelines known as Safe School-Based Enforcement through Collaboration, Understanding, and Respect, also known as SECURE. In a letter from the Department of Education, John King, the current Secretary of Education, emphasized that when school districts do choose to use SROs, that they should incorporate them responsibly into school learning environments and ensure that they have no role in administering school discipline. Now, take a moment to let us know some of your experiences with school resource officers, and you can use the chat box to do so.
Thank you for your responses. SECURE suggests that school resource officers
Well, now with school resource officers, as we have discussed, and certainly as we alluded to earlier in our presentation, a notable video that has come to the public's attention emerged from South Carolina and Spring Valley High School, in which a young Black woman is communicating with her teacher at first, and then a school resource officer is introduced into the equation. As we saw in that video, if you're not familiar, the school resource officer quickly escalates the incident and ends up dragging the young woman from her desk by her neck and across the floor. This harrowing image illustrates how school resource officers have taken the authority that has been invested in them and often abused it.
We know that the incident from South Carolina is just one example of many. From talking to parents and to students on the ground, we've heard many incidences of both violence against students by police officers, where students are, like the video in South Carolina, sort of handled by the police, assaulted by the police. But we also know that police are responding to infractions that are inappropriate for them to be responding to. So we'll talk in a little bit about what the guidance from the Department of Justice and the Department of Education tell us about how police should be interacting in school. But we wanted to share a couple of examples of stories where the police officers have gotten involved in situations that used to be left to the purview of the school principal or even the school counselor. So for example, we know sometimes police officers will involve themselves in classroom management. Sometimes you will have incidents of young people in schools who are talking back to their teachers, who are maybe wearing a baseball hat when they're not supposed to. And instead of dealing with that in the classroom or in the school resource officer is tasked with responding to that student's behavior. And we know that because of that, students are more likely to get a criminal sanction, whether it be an arrest or referral to the juvenile court, because of that typical childhood behavior. Other examples where we see young people getting arrested in school include for things like graffiti, for things like disrupting a school assembly or a school function. And we know that this great expansion of police power in our schools has led to more young people entering into the system, which is something that we're all trying to stop.
Thank you, Caitlin. Now we will provide some more context on the federal guidelines that we mentioned, known as SECURE.
So SECURE suggests that school resource officers, SROs, should be trained rigorously and go through regular evaluation processes to make sure they are doing their jobs appropriately. This is where parent advocates, community partners, and concerned school professionals can step in and hold school resource officers and administrators accountable. We encourage you to maintain regular contact with school administrators to ensure that the SECURE framework is being followed. By remaining involved in your child's school and its discipline practices, you can monitor the actions of school resource officers and articulate your concerns when you detect a potential violation. If you suspect that your child has been subject to discriminatory discipline or that a school is engaging in discriminatory discipline, 2 federal avenues of relief are available to you. Both the Department of Education's Office for Civil Rights and the Department of Justice's Civil Rights Division take complaints related to the violation of your child's rights in school.
We'll certainly detail how to file complaints with both the Department of Education and the Department of Justice, but we did also want to note the SECURE rubric action steps, of which there are 5. They are: 1, to create sustainable partnerships and formalize memoranda of understanding, MOUs, among school districts, local law enforcement agencies, juvenile justice entities, and civil rights and community stakeholders. 2, to ensure that those MOUs meet constitutional and statutory civil rights requirements.
One of the things that were stressed in the SECURE guidelines was that SROs should not be involved in school discipline. And the suggestion from John King, the Secretary of Education, was to draft, if your school has these policies, to push for the removal of SRO involvement in school discipline, in routine school discipline matters.
The third tenet, the third common sense action step, is to recruit and hire effective SROs and school personnel. Number 4 is to keep your SROs and school personnel well trained. And the 5th and last action step is to continually evaluate SROs and school personnel and recognize good performance. Those last 3 tenets in particular provide an opportunity for you as parent advocates or community organizers to step in and ensure that your voices are heard. You can work with school administrators, other coalitions of parent advocates or community organizers who are working to address these issues, and other folks in the community to ensure that if there are SROs in your community, in your children's schools, they are trained effectively, they are evaluated regularly, and as Jessica mentioned, they are not involved with routine discipline matters and are respecting the constitutional and statutory civil rights that are afforded to your children.
So I can talk a little bit about some examples of how this has played out in communities that have already taken steps to form a formal memorandum of understanding between the schools, the police departments, and other agencies, and talk about some of the successes and ways that that can be replicated in your communities. So as we talked about earlier, this is a significant problem because many students are attending schools with sworn law enforcement officers at their schools. Over 42% of high schools have sworn law enforcement officers in them, and 51% of the high schools with high Black and Latino school enrollment have school resource officers or sworn law enforcement officers. We also know that Black students and Latino students are more likely to attend a school with a school resource officer and not with a school counselor. So this is an issue that we know is pertinent to many school districts across the country. A couple of different examples that I can share with you today are from Clayton County, Georgia, from Denver, Colorado, and from Broward County, Florida. In Clayton County, Georgia, what the community was experiencing was that the juvenile court system was completely overwhelmed with referrals from the school. So the school was referring cases to the police who were arresting students and referring them to the court for these really minor misbehaviors like we were talking about earlier, talking back to teachers, getting out of desks, being in the hallway. And as a result, the juvenile court couldn't handle all the cases that were coming before it. And most of the cases that were coming before it were cases that did not warrant or did not need court involvement. And so Judge Stephen Teskey, who's the head of the juvenile court there, convened the stakeholders in the community to get together to talk about what could happen and what they could do to help the school to respond to these students and to the student behavior in a way that didn't land students in the court system. And so what they were able to do in that community was to develop a protocol that set up an agreement about what the schools would do when students were engaging in problematic behavior that did not include referring them to the police and referring them to the court system. And as a result, the arrests and referrals in that community went down significantly. And not only that, but all stakeholders involved reported that this made the operation of the courts, of the police department, and the schools much more smooth. And the police officers that were stationed at the school were much more able to do the job that they were intended to do. So instead of shuttling students back and forth between school and the police department and juvenile court, the police officers were able to focus on investigating serious crime and building relationships within the school. And this helped them to be able to respond to serious safety incidents and not respond to the typical behavior that should be handled by the school administration. The second type of intergovernmental agreement I want to talk about comes out of Denver, Colorado. So in Denver, Colorado, there is a parent and student organizing group called Padres y Jóvenes Unidos, and they have been working on fighting the school-to-prison pipeline in Denver public schools for over 15 years. One of the problems that they identified was the both overuse of school resource officers, but also the fact that the school resource officers were not trained and were not operating effectively in school. So an interesting fact to know about school resource officers is that many of them do not receive any specialized training in juvenile behavior, in school law, or in how to interact appropriately with students. In Denver, Padres y Jóvenes Unidos pushed to convene the school district and the police department to write an intergovernmental agreement that would help to distinguish the role of police in schools and to talk about how the police officers could be trained so that they were not making life worse for the young people that they were working with. What they did was a couple of things. So one is that they put language in about how to distinguish between student school behaviors and crimes. Second, they focused the SROs, instead of engaging in conflicts and escalating conflicts, on how to de-escalate those conflicts and work with young people to make sure that the conflicts are dealt with in the school environment. Number three is that the protocol put in place a series of community meetings and relationship building between all stakeholders, including the students and the parents. So oftentimes what we know is that even if there is an MOU or an agreement between the school district and the police department in your school district, that community and parents and students are not invited to participate in that process, and their feedback is not included. And we know that this is a huge problem because nobody knows better than the parents and students about how the police are interacting with them in schools. And so getting that feedback and getting that input was an incredibly important part of this protocol. And lastly, the intergovernmental agreement addressed training for school resource officers. And particularly, there was training around cultural competency, which we know is an important part of training that most police officers are not receiving. The last agreement that I want to talk about is the agreement from Broward County, Florida. Broward County is one of the largest school districts in the country, and they were able to bring together a broad group of stakeholders, including parents, teachers, community leaders, the police department, the school district, and folks from the juvenile court. And this agreement helped them to replace out-of-school suspensions with an innovative program that holds students accountable by referring them to services that help get at the root of behavior issues and keep students on track academically. One thing that we haven't talked too much about today is what happens to students academically when they're removed from school through suspension, expulsion, or arrest. So oftentimes students are not able to access their work. They can't take tests that earn them the credits that they need in order to pass the class and graduate. And students are much more likely to be suspended from, or much more likely to be held back from school, to fail their classes, or even to drop out of school. And so we know that the programs and the collaborative agreements that we come up with need to make sure that students have the supports they need to continue their education. What was also exciting about the Broward Collaborative Agreement was that it coincided with an investment in interventions for school-based supports for students who were suspended for more serious issues. The last important thing about this agreement, and something that's featured and should be featured in any agreement that you form, is an agreement that there is shared data so that we understand what's happening in schools. We know who is being arrested, what students are being arrested for, and if it is an effective intervention or not. What we often find is that students are being arrested for very minor offenses that do not affect the safety of the school environment, and that there are overwhelming disparities in those arrest rates. And by getting that data, that helps us target our reforms to make sure that we're addressing both the issue of overuse of arrests so that students are not being arrested for minor incidents, but also to address the racial disparities.
Absolutely wonderful. Just as those three very pertinent examples by Caitlin illustrate, there are many activists, parents, and community organizers working on these issues throughout the country, and they have provided their support and effort to other folks who are seeking to either start advocacy strategies in their communities or to improve the advocacy strategies that are already being implemented. Now, with regard to SECURE, and this is available on the U.S. Department of Education's website, with regard to the 5 action steps, the Department of Education provided checklists for starting to implement the action steps, starting with the first action step, which concerns creating sustainable partnerships. Our parent advocates can seek to measure student, family, school, and community experience of school safety and law enforcement presence to just figure out where your starting place is. That goes to the data collection that Caitlin mentioned, seeing what is the landscape of suspensions and expulsions in your community. How do they disproportionately affect students of color, students with disabilities, LGBTQ students? Then you can find resources on best practices for school law enforcement partnerships by studying those examples, such as in Denver or Broward County, Florida. And then you can work with all of these stakeholders to draft an MOU, a memorandum of understanding, to develop that sustainable partnership that is contemplated by the SECURE framework. Secondly, going to the action step that concerns constitutional and statutory civil rights of your children being respected. There is an opportunity to work with organizations, perhaps civil rights organizations or lawyers on the ground, to ensure that you are familiar with the law relating to searches, seizures, uses of force, and interrogations in school. You can seek to go to the Office for Civil Rights website that's hosted by the Department of Education to gather data on disciplinary practices and how, again, these practices affect students of color, students with disabilities, and students who are LGBTQ. That data is really essential to that portion of the SECURE framework, in ensuring that the statutory and constitutional civil rights of your children are respected. Because identifying that disproportionality provides the avenue for filing the complaints that we'll discuss in a few moments here. The third action step concerns recruiting and hiring effective SROs. Now, within this framework, as we discussed, you as a parent advocate or community organizer have a significant opportunity to work with school administrators, staff, and teachers to ensure that what the guidelines for SROs are in your schools reflect what you envision for your child's healthy and meaningful education. This involves collaborating, having meetings with these school professionals, really just letting your voice be heard and being assertive in that regard. The fourth action step, ensuring that SROs and school personnel are trained well. This employs the same strategies contemplated by the third action step of SECURE, in that you can regularly check in with school administrators to see how school resource officers have been dealing with children, not even just your own, and keeping them to the guidelines that you help draft in your community by, again, regularly keeping up and maintaining contact with these folks. And then the last action step concerns the evaluation of SROs and school personnel and the recognition of good performance. This all goes into the understanding that you come up with between yourself as a parent advocate and the school administrator or teacher who is daily involved with your child, ensuring that there is a mechanism to evaluate how school resource officers are interacting with your children and ensuring that they're not being used for routine discipline practices or abusing the constitutional or statutory civil rights of your children, as discussed earlier in the SECURE framework. So now, barring any questions from our audience, we will move on to an explanation of how to file these complaints with the Department of Education and the Department of Justice. To provide some background, OCR primarily enforces Title VI of the Civil Rights Act of 1964, which governs discrimination on the basis of race, color, or national origin. Federal statutes also empower OCR to address issues related to disability, English language learners, and gender discrimination. Parents often work with civil rights organizations and grassroots organizations to identify widespread problems that can be included in a complaint to OCR. Once enough information is gathered, complaints can be filed in one of OCR's regional offices. There are offices in Boston, Chicago, New York, Cleveland, Philadelphia, Kansas City, Atlanta, Denver, Dallas, San Francisco, Washington, D.C., and Seattle. Complaints can also be filed with the Department of Justice's Civil Rights Division. Although parents and partner organizations often seek relief through OCR's process, the Educational Opportunities section of the Department of Justice also accepts such complaints.
And individuals can file complaints without lawyers, and the system is designed to be parent and student friendly. However, as mentioned earlier, you can also work with community partners, lawyers, and civil rights organizations to write and file these complaints. Your state's laws may also provide avenues for relief, and we once more encourage you to visit prepparents.org and download your state's guide for more information.
One important thing to note is that claims have to be filed within 180 days of the moment of discrimination. So if you feel that your child is being discriminated against in school, or if you see an incident happening, You have 180 days, which is about 6 months, to file that complaint with the Department of Education or the Department of Justice. Once they receive those complaints, they do an analysis and will get back to you for more information or to let you know what steps they will take next.
Excellent. Now, at this point in our presentation, we have a few multiple choice questions for you, a small quiz to go over everything that we talked about today. Our first multiple choice question.
So, under current federal law, which of these offenses would warrant intervention by a school resource officer? So we have a student talking back to a teacher, a student bringing a firearm to school, a student not adhering to the school dress code, and a student getting into a verbal argument with another student.
Take some time to use the chat box to start the poll here. One moment.
Okay. You could just go ahead and type the answer in the chat box.
So the answer to that first question is B, a student bringing a firearm to school. We just want to mention that though this is the best answer in the group, we must note that federal law is unclear as to whether a school resource officer must intervene if a child brings a firearm to school.
All right, now is the time in our presentation for a small quiz to review all of the information that we provided to you today. Now, our first multiple choice question. Under current federal law, which of these offenses would warrant intervention by a school resource officer? A student talking back to a teacher. B, a student bringing a firearm to school. C, a student not adhering to the school dress code. Or D, a student getting into a verbal argument with another student. Let's find out the answer. If you guessed B, that was correct. Now, we must offer this disclaimer that though this is the best answer in the group, we note that federal law is unclear as to whether a school resource officer must intervene if a child brings a firearm to school. If a school resource officer interacts with your child for any of the other choices, you should contact your child's principal and express your concern. Keep a record of all correspondence you receive from the school concerning your child and the conduct of the school resource officers. Let's move on to our next multiple choice question. What should you do if you believe that your child has been unfairly disciplined by a school resource officer or a school professional? A, write a letter to the principal. B, express your concerns to the school district or state board of education. C, file a complaint with the Department of Education's Office for Civil Rights or the Department of Justice's Civil Rights Division. Or D, all of the above. Let's find out the answer. If you guessed D, that was correct. All of these avenues are available to you as an advocate. As discussed earlier, and depending on how many other parents or guardians are dealing with the same problem, you can form a coalition of fellow advocates or start working with grassroots organizations to tackle the issue. Filing a complaint with either the U.S. Department of Education or the U.S. Department of Justice takes time, and it can often be a long time before complaints are resolved by the departments. Accordingly, you may want to start with either of the first two options before seeking to file a federal complaint. If you do decide to file a complaint with either of these departments, please be aware that it is illegal for the school or the school district to retaliate against you and your child for filing a complaint. If you have filed a complaint and feel that you or your child is being retaliated against, make sure to keep any and all documentation regarding the issue in order to present it to the Departments of Education and the Department of Justice, as they take incidents of retaliation very seriously. Now, for our final question. What must school resource officers do under the secure framework? A, be the first person to talk to your child after a fight. B, arrest your child if your child talks back to the school resource officer. C, be trained effectively and evaluated regularly. D, search your child when your child enters school each morning. Let's figure out the answer. If you guessed C, you were correct. You can work with the professionals at your child's school to ensure that school resource officers are keeping your child's rights in mind as they interact with your child each day. Now, if there are any questions that the participants may have about any of the information covered today concerning school discipline, we would like to direct you to the websites of both of our partner organizations. You can visit prepparents.org and advancementproject.org for more information. As always, we want to remind you that as a parent advocate, you have a great deal of power to influence how your child is educated and ensuring that your child has a healthy and happy learning environment. Now, with school discipline, these issues will likely continue to grow in public conversation. And so we advise you to visit the Department of Education's website as well as the Department of Justice's website to learn more information about what the federal government is doing to respond to these issues. And certainly we encourage you to work with other partners in your community and coalition members that you may find to address these issues. Thank you for tuning into our webinar, and we hope to work with you again soon. Take care.